Switzerland's Federal Council has declared war on the free speech of the Swiss people. It has declared war on our free speech by proposing a Swiss version of the European Union's Digital Services Act. Like its European counterpart, the Swiss DSA establishes an industrial censorship complex. The Swiss Digital Services Act applies to large social media platforms and search engines such as Google, Facebook, Instagram, YouTube, and X. As with the European Union's DSA, severe fines are foreseen. The companies may be fined up to 6% of the average worldwide turnover achieved in the last 3 financial years, if they fail to comply with the law or implement it incorrectly. In cases of serious non-compliance with the Swiss Digital Services Act, the public may even be denied access to platforms like X, as has temporarily already happened in Brazil. The most important feature of the Swiss Digital Services Act is its obligation for platforms like Facebook to delete allegedly illegal content. That is a direct quote. These platforms need to censor content that is, quote, allegedly illegal, end quote. And users are invited to report content which they consider to be allegedly illegal. Once such a report is made by a user, the platform must decide whether it regards the content as allegedly illegal itself. If it does, the Swiss Digital Services Act obliges the platform to censor this content. This is the mechanism. We can now proceed to analyze it. We must begin from a single premise. Everything is legal until a judge or a court has ruled it to be illegal. This is not just a simple premise. It is the foundation of our justice system, of due process, and of the principle of innocent until proven guilty. It is a legacy of the Enlightenment. From this simple and all-important premise, everything that follows is unavoidable. The central phrase of the Swiss DSA is allegedly illegal. Now we must ask what this phrase actually means. What does allegedly illegal mean? The answer is simple. Allegedly illegal means legal. Allegedly illegal content is legal content. Nothing else. Period. This is basic philosophy. The logic is elementary. An allegedly illegal post is, by definition, a legal post. Alleged illegality presupposes the legality of that which is alleged to be illegal. That which is illegal is not allegedly illegal, it is simply illegal. Everything legal is potentially illegal and can therefore be alleged to be illegal. Allegedly illegal means that someone is alleging that a legal post is illegal. That which is illegal is not potentially illegal. It simply is illegal. The conclusion is clear. The Swiss Digital Services Act's purpose is to censor allegedly illegal content. This means that the Swiss DSA's purpose is to censor legal content. In fact, it can only censor legal content and nothing but legal content. In fact, it is logically impossible for the Swiss DSA to censor illegal content. For this reason alone, it is already a totalitarian law. The problem is made worse by the misleading nature of the phrase allegedly illegal. The phrase allegedly illegal suggests that the standard being applied to judge and measure whether something is allegedly illegal is the law that defines illegality itself. The Swiss DSA lists 9 articles of the Criminal Code of Switzerland as the standard for determining what counts as allegedly illegal. These articles of our criminal law include the provisions on slander, depictions of violence, and calls to discrimination or hatred. What this means in practice is that platforms like Facebook censor legal content while claiming to rely on the criminal code to justify this censorship of legal content. This abolishes the rule of law itself. It is deeply totalitarian because the criminal law exists to define that which is illegal. The criminal code does not exist to prohibit that which is legal. This is a basic principle. That which is forbidden does not forbid that which is allowed, by definition. At the moment, we live in a legal order in Switzerland in which everything is allowed until it is forbidden. The set of prohibited acts is finite and defined by a criminal law and other statutes. The Swiss Digital Services Act attempts to use the criminal code to censor everything that is legal simply because it is alleged to be illegal. So, they can't be using the criminal code to censor and forbid that which is legal. So the question is, if they can't use the criminal code as a standard to censor the legal, what standard are they using instead? Well, the Swiss Federal Council's explanatory report makes it quite clear what standard they are using instead. It's called hate speech. And hate speech isn't even a legal category in Switzerland. It is neither a crime nor an offence. It is not a legal term. Hate speech can mean whatever Facebook or the judge want it to mean. Hate speech can be illegal, of course, in Switzerland, but only as something defined in the criminal code. So, hate speech can be illegal as slander or depictions of violence, for instance, but not as hate speech itself. But the Swiss Federal Council wants hate speech to be allegedly illegal and illegal as hate speech. That makes no sense. How can hate speech be allegedly illegal as hate speech if hate speech isn't illegal to begin with? This focus on hate speech serves to punish dissent against the prevailing orthodoxies of the day, period. It is pure arbitrary power. The next problem concerns the appeals process created by the Swiss Digital Services Act. If a user wishes to seriously challenge Facebook's decision to censor his legal post, the user who was censored may take Facebook to court. But this will not be a criminal proceeding or criminal court. It will be a civil proceeding, a civil court. The dispute is between a private individual and a company like Facebook. It is not a dispute between the citizen and the state. A judge in a civil proceeding cannot declare anything illegal under the criminal code or criminal law. That is structurally impossible in our legal system. This means that throughout the entire appeals process or complaints process under the Swiss DSA, your censored post remains unquestionably legal, regardless of whether you win or lose in court. It will never be declared to be illegal by a judge, and yet it can and will be censored. And that is the point of the entire Swiss Digital Services Act. So, what can a censored user who goes to court against Facebook argue in front of the judge? One might argue, as a user, that Facebook was wrong to censor the post because the post is legal. This argument fails immediately. The legality of the post is not in dispute. The judge will not declare it to be illegal. Everyone involved agrees that the post is legal and will remain legal throughout the process. Moreover, the legality of the post is the very necessary condition which allows Facebook to classify it as allegedly illegal. Only legal content can be potentially illegal. So by definition, allegedly illegal content is legal content, as we've previously discussed. Facebook, therefore, agrees that the post is legal. It merely claims that this legal post is allegedly illegal. To argue that the post is legal is to confirm the necessary condition that allows Facebook to censor it on the grounds that it is allegedly illegal. We must therefore conclude that when Facebook deletes a legal post under the Swiss Digital Services Act, it is not making a mistake. It is doing exactly what the law requires. Legality is no longer a defense in court. Now, under normal circumstances, legality is a rational and decisive defense in court. Here, it is irrelevant and not a defense at all. Perhaps the user could argue instead that the post is not illegal. This argument also fails. Facebook is not claiming that the post is illegal. Illegal content is not allegedly illegal. It simply is illegal. Facebook, however, is not claiming that the post is illegal, but that the post is allegedly illegal. The judge is therefore not asked to decide whether the post which was censored is illegal. The judge is asked instead to decide whether Facebook was justified in deeming the post to be allegedly illegal. Arguing that the post is not illegal misses the point entirely. Under ordinary circumstances, arguing that a post is not illegal would be a rational defense in court. Here it is futile and a straw man. What can the censored user argue next? Well, he could try to argue that his post is not allegedly illegal, but allegedly legal. This collapses into nonsense. A legal post is not potentially or allegedly legal, it simply is legal. And since legality is no defense in court, potential legality is no defense either. What remains for the censored user is to try to refute Facebook's allegation that the post is allegedly illegal. This, too, is impossible. Claims about potentiality are by their very nature irrefutable. If someone suggests that you are potentially a thief, the accusation is irrefutable. It can neither be proven nor disproven. Facebook's allegation that a post is potentially illegal cannot be refuted by the user, and it cannot be refuted by the judge either. The Swiss Digital Services Act therefore creates a profoundly unjust argumentative asymmetry. On the one side stands the platform, with a seemingly reasonable, perfectly logical claim that a legal post might be illegal. On the other side stands the user, stripped of every rational defense and forced into incoherent and futile arguments about possibility. The conclusion is unavoidable. The Swiss Digital Services Act censors only legal content and nothing else. The censorship is automatic. Once a platform classifies a legal post as allegedly illegal, it must delete it. If the user goes to court, the post remains legal throughout the process. The user cannot win because the claim of alleged illegality is irrefutable and presupposes legality. And throughout this process, criminal law is cynically invoked to censor what is legal. This is a totalitarian absurdity in every respect. The Alliance for Free Speech, Bündnis Redefreiheit in German, is fighting this Swiss Digital Services Act all the way. If you want to help us, donate over our website or sign up as a helping member via our website. This was me, Andreas Seaman of the Swiss-based Free Speech Alliance. Thank you very much for listening. Over and out.